Okay, so let's talk a little bit about the contracts. The contracts are broken out into two main components. There's the option agreement. So when David talked, he talked about how he signed an option. That option agreement usually is for 5 years, but in Port Burwell, there's a group of growers there that went with another company, which is Eco Energy, the natural gas company. They are being held to a 40-year option agreement. Payments are usually $1,000 a year, and once you sign up, you are bound automatically to the contract. So you're actually signing two different components, but there's two different components to the contract. You sign one, but you're automatically signing the other one. But the wind company, during that 5 year, can pull out anytime they want. And so the other part is the land lease agreement. It's usually for 20 years with an automatic renewal for another 20. Some are up to 50 years. And the revenues are based on the percentage of the sales. So the average of all the turbines in the project area. So your turbine may be producing, let's say, 45% of its capacity, but it gets averaged out with everybody else's, your neighbor may only be producing 10. The option agreement, again, you should consider this because 5 years is a long time to tie up your land. You can't do anything unless the company gives you permission. It inhibits your other developments, so if you want to put up a pig barn, if you want to put up a dairy barn, you want to put up another building of any kind, you are inhibited from that. It doesn't guarantee you a turbine if you sign an option agreement. You could be subject to no setbacks as well. I have a grower that called me from the north end of the county. He's all upset because his neighbors have signed with a different company. He didn't decide to sign with that company, but he has signed with another company. And guess what? Because he's considered in the project area, his neighbor can put his turbine on his lot line. It's actually impinging on his ability to put up his own turbine. Believe me, once that option agreement expires, and hopefully David, yours expires in another 2 years, this December, you are not obligated to resign. There was a group of growers in Port Burwell that were told by the lawyer they had to resign. They went to court, from what I understand. And there was so much pressure, there was about 7 growers. There was so much pressure on these growers, 3 of them caved in and said, okay, we'll sign. And that was for a 40-year option agreement. We should make a distinction. What is an easement? What is a lease, right? You know, if you're going to be sweeping over your neighbor, well, in this case, this grower that contacted me, he's not going to get it. He's getting nada, even though he has these blades sweeping over his property. Make sure that if you're going to sign, that it's not an easement. Make sure it's a land lease agreement. Easements are extremely difficult to discharge from your deed. They have to register to your deed. And they're difficult. If you're trying to will your land to another family member, or son, daughter, whatever, it'll be very difficult to discharge to get that to them. Because, especially if you're trying to sell, right? Because what happens is the company wants first rights of refusal. They get the first dibs on that, right? So that means, first of all, what mortgager is going to allow that? It's going to cost you a lot of money to get your mortgager to agree to that, and I don't really think that's going to happen. You should also understand things like construction liens. In the US, there was a huge case where Noble or Florida Power and Light, they were having financial problems. And these people, the people who were hired to construct the turbines, actually put liens on the grower's land to be able to recoup the cost, the fact that Noble bailed out on them. Also make sure that the land lease agreement is only on very specific pieces of ground that you want the turbine on. If you don't want it on another piece of ground, make sure it's specified. The terms, the reason why it's 20 years is because of the Planning Act in Ontario. The Planning Act says after it's more than 20-year lease, it has to be an easement. So the companies cleverly got around this by saying, oh, we'll just do 2 at 20-year and 20 years. We'll just automatically renew. And that saves them money, right? And it saves them the hassle of having you to resign. You should also make sure that you are aware of the time of renewal. You should be given a few days. Many times it's only a day. If you're not on top of that, You may not want to resign, but lots of times what happens is you get to it'll automatically happen. Future revenues, they depend on, you should also understand that there's that FIT program under the OPA, which is the feed-in tariff. It runs in 14 to 19 cents per kilowatt, 19 cents being an offshore project, 14.5 cents is on land. You only get about 2 to 3% of that straight outright payment per year. That's usually the contracts run in those percentages. They may be higher, I don't know. It usually ranges between 5,000 to 12,000 per year per grower. But let's say do you get revenues during construction? And how do you verify your income? Are they going to show you how the output of that particular project is so that you can verify? Other pitfalls, like I mentioned, is first rights of refusal on the sale of land or on the development or granting future rights, for example, gas, gravel, and other renewables. So in other words, when it comes time for you to sell your property, you have to give the wind company the first dibs on that. So if you get a bid from your own son or daughter at this level, they get to counter that higher because they have the first rights of refusal. So that to me indicates this is a ploy almost to grab agricultural land. They're planning to take over. In my mind, I see this as taking over our future agricultural lands. Also, in our contract, we had this thing called postponement of mortgage, which means that if I go defunct, I have to make arrangements with my mortgager that if I go defunct on my mortgage, the company gets my land.